Okay, so I think we are going to get started. Um, Good afternoon. I'm Jason Mazzoni, and I'm a professor here at the University of Illinois College of Law. Thank you for joining me. It's good to see you for this CLE program on constitutional issues that are raised by governmental responses to the coronavirus pandemic. This is a series of CLE programs that the College of Law is hosting, and I encourage you to keep an eye out for future programs and to join us for those. And one of the one of the few positive aspects of the pandemic and all of the restrictions upon us is that we run these online programs, and so can include people who might not be able to participate in person. So I'm glad to see you. Thank you for joining us. My plan in this session is to discuss some key constitutional questions that have arisen already as governmental actors have undertaken responsive measures. I want to talk a bit about some of the lawsuits that have been brought and how courts have so far decided them, and preview some issues also that perhaps lie further ahead. This is it's a big topic. It's keeping me busy almost every day. It seems like there's something else in the news, and we're not going to cover everything, but I hope to give you a pretty good overview. I will save some time for questions towards the end of the hour. Something occurs to you as I'm talking, please just type it in the text box, and I'll try to get to as many of those towards the end of the session. I should also note that the session is being recorded, so if you don't want to be, recorded, don't unmute yourself and speak. But the session is going to be recorded. So I want to start, I guess, by putting the issues that we're talking about today in a broader context. It is tempting to think about the coronavirus pandemic as presenting entirely new problems. Our lives have changed drastically. There are new and exceptional challenges for us. We see government doing things that just a few months ago it wasn't doing, and we probably wouldn't have imagined it doing except in some hypothetical scenario. Our freedoms have been curtailed in significant ways. It all looks new. And in a certain sense, that's right. There are certain features of the pandemic that generate novel problems. But when we start to think about the Constitution, it is important not to overstate the novelty of our current situation or the challenges that exist. So the questions that we face today might be new to us, but many of them have arisen in a general sense before, even if not perhaps in the exact same form as they are arising today. Importantly, the people who wrote and ratified the Constitution understood emergencies, including what we would call today public health emergencies. They had experience with the mass outbreak of disease and illness and large-scale deaths and all of the disruptions that result. Now, of course, Americans at the end of the 18th century didn't have the same scientific knowledge about how diseases are transmitted or might be controlled and cured, and the problems that could arise in what was a remote outpost of the British Empire were not the same that exist today in a country like ours with dense population centers and people traveling around by aircraft. But emergencies were understood by the founding generation. And the Constitution is built with an expectation that emergencies will occur, including emergencies that may threaten the entire system. When the early sense was that the constitutional system, the republic is fragile, it might not survive. You better plan for risks because risks are inevitable. If you read the Constitution from beginning to end with an eye to that issue, you'll see that multiple provisions actually make sense as built-in emergency measures. So I say that because it's really by way of making the point that it's probably a mistake to think that our constitutional provisions apply in exactly the same way in extraordinary circumstances as they do in normal circumstances, that there just cannot be any sort of adjustment. That's probably wrong, but it's also a mistake to think that we just set aside the Constitution entirely until the pandemic is over and we're back to normal, that somehow it just all gets suspended. There are constitutions around the world, India, South Africa, Portugal, Brazil, Ireland, and many others, with provisions for government to declare a state of emergency and exercise special powers, and with constitutional rights just suspended. Our Constitution doesn't have that sort of provision. The answer to a constitutional question for us might be different in an emergency, but the Constitution still fully applies. So then a useful way, I guess, of organizing issues that have emerged over the past few months, and there are many of them, and it's easy to get overwhelmed if you try to kind of keep up with all of the developments. But a useful first way of organizing things is in terms of some big themes that are reflected in the Constitution itself. And so let me start there and say, well, two big themes. One big theme is the allocation of government power. And here we distinguish between two things. One is federalism, the division of power between the federal government and the states. And then the other is a separation of power. So among the branches of the federal government, power is divided. Now, you know this, but it's a useful starting point for thinking about the constitutional issues that are in play. Then a second big theme, the first one is allocation of powers. Second big theme is individual rights. And so then a couple of things about this. The first is that these two big themes, power and rights, are related, and I don't want to suggest that they're not. Dividing up government power has implications for rights. The second point is that I'm only going to talk today about the federal Constitution and federal constitutional issues. But of course, at the state level, you also have further divisions of power between states and cities and other subunits. And you have separation of powers among the branches of state government, the legislature and the courts and the executive, and sometimes that's divided between the governor and the attorney general and others. And of course, you have state constitutions that protect rights, sometimes in the same way as the federal Constitution does, but often differently. And constitutional questions at the state level and in state court are an important part of all of this. And while I'm focusing on the US Constitution, please don't think that those 50 state constitutions don't matter. We could do an entire program on state constitutional issues and state constitutional cases. And there's a good amount of the litigation that has occurred that is based purely on state law issues. So just one example that you might have seen in the news, the Wisconsin Supreme Court, for example, invalidated back in May the extension of the stay-at-home order in that state on the ground that the executive branch that had issued the order had exceeded its authority under the state constitution, that if you're going to have this kind of thing in place, you need the state legislature to authorize it. So purely a state constitutional law question, no federal constitutional claim in that case. All right, well, turning then to federal constitutional issues and starting with questions of power and federalism and separation of power. And the basic issue here is who gets to do things and who doesn't get to do things. Does the Constitution give the federal government, which is, as you know, a government of limited enumerated power, authority to act? Or is the power reserved to state government so that federal action that we see is unconstitutional? When the states act, are they running afoul of federal power, either because the federal government has properly acted or could act, and so states have to step aside? And then on separation of powers, there's similar kinds of questions. But what can the president do alone? What requires congressional authority? What can the president do in defiance of Congress? And then we don't want to forget about the third branch. How about the courts? What is their role, including in policing exercises of power by the other two branches of government at the federal level, in policing federalism boundaries, and of course in protecting rights? And how does the role of courts differ, if at all, during a pandemic or some other emergency, when perhaps actions are being taken quickly? Certain people have information, but others don't. Maybe courts can get a good handle on things. Maybe courts are concerned about issuing rulings quickly and with incomplete information in ways that might have really dramatic circumstances. So how do we think about that? How do courts think about that? How have courts been thinking about that in the cases that have been appearing? Well, on the federalism front, as you probably observed, the states, and particularly the governors, have been playing a leading role in terms of formulating and implementing responses to the pandemic. Well, this makes a fair amount of sense. The pandemic is a national problem, of course, but the problem is not evenly spread around the country. Some states have been hit far harder than have others, and states are also, of course, different in terms of population densities and other factors tied to the intensity of any outbreak, and reflective of the sorts of response measures that would make sense. But most importantly, when you're talking about contagion, places where people come together are mostly regulated by the states as a matter of what we call their police powers, the sort of traditional domain of state authority. Schools, parks, beaches, restaurants, public streets, shopping malls, right? These all fall within the domain of state authority. Now, this isn't to say that the federal government could not regulate any of these things. I think there's no question that under the Interstate Commerce Clause of the Constitution, Article 1, Section 8, Congress can regulate restaurants and other commercial entities, and it already does in certain ways. So think about, say, federal non-discrimination laws, federal employment laws, and so on. But in terms of existing legal regulations that become useful during a pandemic, it's mostly state and local government that's been exercising power and whose powers become particularly useful and important. It's also the case that there are many more state and local officials who can implement measures and enforce the rules. So just think about restaurants. There's something like 1 million restaurants in this country. There's no possibility that the federal government could send out sufficient numbers of federal officials to enforce a restaurant closure order, or to make sure that people are seated in restaurants 6 feet apart. You need, if you're going to have something like that, state government, particularly local government, carrying out these functions. Now, in some ways, a federalist design can be helpful in a health emergency or other emergency. So I've already mentioned variations in outbreaks and risks justify variations in response measures. And so federalism accommodates that. It allows for the tailoring of the response in light of local conditions. What makes sense in New York City probably doesn't make sense for us here in central Illinois. And federalism can accommodate those sorts of differences in a way that perhaps just a single rule imposed by the central government does not or can't do in quite a sufficiently sensitive way. Federalism is also beneficial if you think that the national government is ineffective or incompetent or lacks the political will. The worst possible scenario would be the states are prohibited from acting in response to an emergency or some other pandemic, and the federal government isn't doing anything or doing it badly. But there are costs to federalism as well. Costs to pushing authority down to the state and local level. States can regulate within their own borders successfully, it's much more difficult for them to regulate across borders. But a virus does not respect borders between states. A threat can arise from another state, including because people are traveling in from another state. And there's really very little that a state can do in our federalist system to require a sister state to take action to mitigate those kinds of risks, or to block the threat that takes the form of somebody traveling in from that other state, right, bringing in a risk that has, of course, repercussions for the members of the state. The states cannot generally impede the movement of people into the state. Rhode Island might not want millions of New Yorkers to come to Rhode Island for the summer, but the constitutional right to travel that the Supreme Court has long recognized prevents states from closing the border to visitors from other states. Under Article 1, Section 10 of the Constitution, states also cannot impose, say, economic sanctions or other punitive or deterrent measures upon neighboring states to try to coerce them or incentivize them to beef up their own response measures because of spillover effects. Our system really doesn't allow that sort of dynamic between states. So in a federal system, there is a risk of individual states under-responding to an emergency when there are, what my economist colleagues would call externalities, when some of the costs of the emergency are felt not by you, but by some other state. And likewise, when some of the benefits of your response or your investment in a response are captured or enjoyed by not you, but by your neighbors. So then the incentive is to underinvest. So to think about this, Florida, as it did, can open its beaches to spring breakers from out of state because Florida captures the economic benefit of their visitors. And then if 2 weeks later they're all sick, well, they're already back in their home states, and Florida doesn't bear the cost or doesn't bear the full cost. So even if you're a strong believer then in state or local power, there are some things that don't work when power is pushed down. There are certain responses that require federal intervention, the role of the national government. I've talked about interstate dynamics. I should also say that there's an international component to the spread of the virus, of course, and here the states are really disabled. States have no power to restrict entry from abroad. One reason is that international border control, immigration is regulated heavily, comprehensively by federal law, and so a state law would be invalid under the supremacy clause of the Constitution. And the Supreme Court in the modern era understands the control of the national borders, questions about who can enter, under what conditions, how long they can stay, and so on, to be the exclusive domain of the federal government, whether as an implication of the Uniform Naturalization Clause of Article 1, Section 8, or just a necessary attribute of national sovereignty. So the restrictions, and we have them in place now on travel to the United States from countries with high outbreaks of the virus, you could only get from the national government. So in an emergency, you might push power down because you conclude states and localities can play a useful leading role, but you might need to push it up because there are things that they can't do or can't do well, can't do effectively. And that pushing up raises questions of whether and how the Constitution authorizes the national government. Remember, government of limited and enumerated power is permitted as a constitutional matter to act. And it's not necessarily the case that what makes for a sensible public health policy is one that is fully authorized or supported by the Constitution. There could well be a mismatch between those things. The Constitution might get in the way of certain effective public health measures. Okay, so let's get a bit more specific and talk a bit about the role that the federal government has been playing during the pandemic, and to think as a constitutional matter about how it's been doing. Well, most of what we have seen by the federal government over these past months strikes me as basically uncontroversial from a federalism perspective. So far, at least, the federal government has not regulated in ways that, as far as I can tell, would raise serious doubts about whether there's federal power to act. I'll get in a moment to some of the things that the president has suggested the federal government or he alone might do, and then the story is a bit different. But in terms of what the federal government has done, is doing, I think there's pretty solid constitutional authority. As a few big examples. I mentioned already the regulation of international borders, who can come in, who cannot, health screening measures at the airports. These things are easily within the scope of federal power. And then on the statutory front, we have three new statutes enacted and signed into law. Let me just mention them very, very quickly. One is kind of going in order. March 6th, we get the Coronavirus Preparedness and Response Supplemental Appropriations Act. This provided $8 billion or so in emergency funding, kind of quick response to outbreaks, to federal agencies to purchase medical supplies, to help develop quickly a vaccine, money to evacuate U.S. citizens from abroad. The next statute, second of the three, March 18th, the Families First Coronavirus Response Act, designed to provide economic and other forms of relief to family members in light of course, changed circumstances, working at home, loss of employment, and so on. This time, much more money, $100 billion, including grants to states related to increased unemployment compensation claims at the state level, money directed to programs to provide food to poor families, to substitute for school lunch programs because kids are, now suddenly at home. Also now some regulatory measures, including that employers provide paid leave to their employees who become sick as a result of coronavirus because they're caring for a sick family member. It's not all employees or employers, but a fair number, up to 10 weeks. Or because of sudden childcare needs, because children are at home and you can't find somebody to take care of them, obligations on the part of employers. A requirement also that health insurers, and of course many people receive their health insurance through employment, cover the costs of COVID testing. The big one, though, is the CARES Act. It's the if I get this right, the Coronavirus Aid, Relief, and I think it's Economic Security Act of March 27th, $2 trillion and something of spending, relief and stimulus package, lots and lots of provisions, direct payments to individuals. Maybe you received some funding from the government, billions of dollars in forgivable loans to small businesses to help them out, massive funding for the healthcare sector, funding to add supplies to the strategic national stockpile, which, as you may have found out, turned out we didn't really have enough stuff in terms of medical equipment, ventilators, and even masks and so on, to kind of replenish what's been taken and to build that out for the future. Suspension of federal student loan repayments, money, billions of dollars for affordable housing, a supplemental federal unemployment compensation program, even funding to provide for broadband access to rural communities because of the shift to online education, money to help states prepare for the November election, money for the Bureau of Prisons to purchase protective equipment, other things as well, including various regulatory provisions allowing the FDA to fast-track drug testing, conferring immunity upon the manufacturers of respiratory protective devices, so they're not held liable, and development, get them out quickly. Some changes to the tote, a big important piece of out of the federal. These three laws are mostly spending measures. So easily a proper exercise of Congress's power under the taxing and spending clause of Article 1, Section 8, the very first thing on that Article 1, Section 8 list, which lists the things that Congress is allowed to do, right? That's the first thing. There are regulatory aspects, as I mentioned, but I haven't seen any constitutional challenges to them. And I think many of the provisions under these statutes would also be justified under Congress's power to regulate interstate commerce. So the employee sick leave provision, for example, or requiring health insurers to cover costs of testing, or fast tracking of devices and drugs, or the relief of liability upon development of certain medical devices. These all, I think, easily fit within Congress's Commerce Clause power. But the spending piece is the big theme here. And if you are just talking about spending money, the only constitutional requirement is that the spending serve one of three purposes under Article 1, Section 8, that it be to pay the debts or for of the United States, or for defense, or for the general welfare. And these statutes, these funding statutes, easily qualifies. The CARES Act is the biggest stimulus package ever by far, but as a constitutional matter, big is not bad. And some of the funding is funneled through the states with conditions attached, and there's some constitutional doctrine there, and some limits upon what Congress can do in terms of structuring those sorts of arrangements. I see some of my students are here now, know all about that. I'll get back to that in a moment. But again, quite free range on the part of the federal government. So that all seems pretty solid as a constitutional matter. What else is the federal government doing? Well, it's been disseminating a lot of information by internet or by email. You may have received even postcards in the mail, a whole slew of federal agencies distributing information about everything from which disinfectants kill the virus to advice for educators, information for people with chronic health conditions, how to manage your finances, how to avoid internet scams, and so on. And here again, I don't think there's any plausible constitutional objection. If there's power to create the federal agency, to fund it, and to give it a job to do, then under a long line of cases, beginning with McCulloch versus Maryland, the agency can make public announcements as part of carrying out its functions. So far, so good. It's possible to imagine other sorts of things, a more heavy-handed national government doing things besides handing out money and information. In fact, we don't have to imagine, because in other countries that are not federalist systems, the national governments are running the response, and also because here at home, the president himself has floated some possibilities for a much stronger national government role. So think about some of those options. Let's say the federal government decides that it is going to impose stay-at-home requirements or business closure requirements, and it is going to decide what those sorts of when those sorts of rules are going to be lifted. So these things are no longer then determined by states and localities. Maybe the feds decide they're not doing a good enough job, and so the federal government wants to intervene. You might remember President Trump in the spring suggesting, among the various things that he said, that he would decide when it's time to reopen, and he would override decisions by the governors. He ultimately backed on that suggestion. But could the federal government regulate here? Say again, because it thinks that the states are not doing a good enough job. That's your federalism question. And can the president do it alone without a statute in place from Congress? That's your separation of powers question. What are the possibilities? What are the possibilities here? So let's break things down a little bit and assume that Congress has a statute, so the president can assert statutory authority. Well, with any sort of business or commercial, and I don't think there's any doubt that Congress, under the Commerce Clause of the Constitution, could shut things down, could require businesses to close and decide when they may open back up. The power to regulate interstate commerce includes the power to stop interstate commercial activity from occurring, and virtually every commercial enterprise, however local it looks, is involved in some form of interstate commerce. So Congress then can easily override state laws on this issue. In addition, in exercising that power, Congress can even sweep in, the Supreme Court has told us, even localized, so not interstate, but localized and even non-economic activities that could undercut its regulation of the interstate economy. That's a case called Gonzalez versus Raich. Again, my students will remember this one. So let's say that all of the stores are ordered closed down and people turn to bartering instead, right? No money being changed hands. Congress, if it wanted to, I don't know why it would, but Congress, if it wanted to, could probably stop that too, right? If it thought that there was an associated health risk. With respect to individuals, a national stay-at-home order is harder to justify, but maybe not that much harder. The Commerce Clause could do some of the work. You could, for example, easily stop people from driving around or from taking mass transit. So no automobile made in interstate commerce may be driven, or no gasoline may be sold. Probably harder to see, though, how the Commerce Clause would allow Congress to stop you from just walking around the neighborhood. But there's another power that Congress has, and if it really wanted to shut us all indoors for a period, might be able to use not the Commerce Clause, but Congress's, and there hasn't been a lot of talk about this, but Congress's military powers. So think about this: Congress has power to raise and support armies, to provide a navy, to make rules for the government and regulation of the land and naval forces. Remember, again, I said lots of provisions of the Constitution are these kind of emergency measures, and national security is a big emergency concern. These are all powers in Article 1, Section 8. If Congress has power to create armed forces, then it has power to take measures to protect those armed forces. That, again, is McCulloch versus Maryland, including from a threat that takes the form of a contagious disease. Right? Military readiness then might be a hook that would allow Congress to impose broad and intrusive measures to keep us at home, to keep the armed forces, who of course spread throughout our communities, safe. Now, there's going to be questions about reasonableness and alternatives and how long it goes on and so on, but this might also be, again, it's not being talked about, but might be an important source of regulatory authority. If we change the presumption and talk separation of powers, how about if you don't have a federal statute and the president is acting alone or maybe acting in defiance of Congress? Congress said, no, president, you can't do this. Trump, remember, said earlier, well, I have total authority here. Does he? Well, the president does not have a Commerce Clause power. That belongs to Congress. But the president does have some powers under Article 2 of the Constitution, or Article 2, Section 2. First thing on the list, remember my first point, this is very much an emergency document. The president shall be commander-in-chief of the Army and Navy of the United States. That, I think, would allow a president, at least as an initial immediate response to an outbreak, to go to alone to oppose even perhaps a shutdown or a stay-at-home order so as to protect the armed forces, including members of the militia. You all, right, listening today, you're all part of that, all right, dispersed throughout our communities from disease. It's likely that after a period of time, the use of that power alone by the president becomes less persuasive, less justifiable. But certainly the morning after a national emergency, the president is in a strong position to act. This idea would not have been unfamiliar to the people who gave us the Constitution. They understood the difficulties of convening a legislative body, Congress, on short notice, and the need for the executive to be able to act to protect the country. Again, it's not unlimited. It probably doesn't let the president, say, override a governor's stay-at-home order, so the power doesn't flow in every direction. Congress could also get involved and limit presidential action, certainly at some point. The last possible source of federal power with respect to shutdowns or stay-at-home requirements, if the federal government wanted to start thinking about these things, it goes back to spending. Congress can and often does impose conditions on funds that are allocated to the states. Federal grants often come with conditions. State, if you want the money, you have to do these things that we, federal government, want you can do. It's a huge source of federal power. Allows the federal government to achieve outcomes, to achieve regulations that it itself could not impose, but that it can essentially bribe the states to impose. The case that's relevant here is South Dakota versus Dole. It's a Rehnquist opinion that blesses these kinds of arrangements, conditional spending arrangements. That case involved Congress denying a portion of federal highway funding to states that did not agree to raise their drinking age to 21. The court upheld this arrangement. The state had the choice. You didn't have to take all the money, right? And you could stick with your lower drinking age. But if you took the money, that the condition kicked in, and the court said that's fine. The court in that case in Dole suggested there might be some federalism-based limits on these sorts of arrangements. The one that got the most attention in the case is the idea that there has to be some kind of relationship, a nexus between the purpose of the grant program, why is Congress spending the money, and the condition that is being attached to the funds that are being offered. Rehnquist in Dole was quite vague about what this requirement means, and even if it is a constitutional requirement, and the Supreme Court has never invalidated a constitutional grant to the states on this Nexus program. But if we play this out, it wouldn't be hard to come up with spending programs. Remember your $3 trillion stimulus package from March that makes funds available to the states with a requirement that they enforce specified business closure or stay-at-home requirements. Federal funding for schools comes with lots of conditions. Would not be difficult for Congress to attach a requirement to educational grants that say you only open up when given the green light by the Department of Education, or you attach conditions to federal unemployment compensation grants to the states, or to small business funds you make available to state government. Lots of opportunities here. This is conditional spending is a way, again, for the federal government to achieve outcomes through the vehicle of the states, outcomes that it may lack power to enforce directly, or may lack the people to enforce a federal program on the ground. So let's imagine that things really go downhill, and we need, or they don't, but we need a very sophisticated contact tracing program everywhere in the country, or we get a vaccine, hopefully it's coming, and we need everyone to be vaccinated. The federal government doesn't have the personnel to do it, to do these things. If the federal government is going to do these sorts of things on a mass scale, it needs state and local government involved. But the problem is that the federal government cannot just order state and local officials to implement federal law or federal programs. That's what we call the anti-commandeering doctrine. Okay, and one of the cases, the United States versus Prince, held unconstitutional for the federal government to require local law enforcement officers to carry out federal background checks for firearm sales, over dissent by Justice Stevens in that case, who said, well, wait a second, the mass inoculation to forestall an epidemic may require a national response before federal personnel can be made available in sufficient numbers to respond. The Prince majority, Stevens is right, says no, the federal government doesn't get to enlist state and local personnel in that way. Conditional spending is a way around the problem. We will fund vaccine grants to the states, but if you take the money, you must administer the vaccine program in the way we tell you. Back to separation of powers for a moment. South Dakota versus Dole was a case involving Congress attaching conditions. But what if it's not Congress, but the president? President Trump recently suggested that he would tie the distribution of federal pandemic relief funds to cooperation by the states on immigration enforcement. So that states that insisted on being sanctuary cities, something that Trump has been long concerned about, who refuse to help the federal government identify individuals not lawfully present, they're not going to get the coronavirus relief funding. Setting aside this nexus requirement that I talked about, one of the puzzles in the conditional spending doctrine area is whether the conditions, if there are going to be conditions, have to be imposed by Congress itself, or can the president generate the condition so long as, again, the state has notice and can say, no, we're not going to accept the deal. And then what kind of authorization to the president to do that does Congress have to provide? How specific does that have to be? South Dakota versus Dole doesn't answer that. There's no other Supreme Court case that answers that. There's a circuit court split on this issue. We may give we may get some clarity on that, or maybe greater confusion in the next couple of years. This is something that the current president has been very interested in. Trump has not so far sought to impose conditions on receipt of pandemic funding. Indeed, for a president who has invoked his own powers under Article 2 regularly since taking office, so far his responses that have been implemented have mostly been based on, and I think it was entirely based so far in terms of what has been implemented, on powers that have been given to him by statute. Under the Stafford Act, for example, allows for deployment of emergency funding. The Public Health Services Act that allows the president to take measures to stop spread of disease from abroad. The Defense Production Act that allows the president to require factories to prioritize U.S. government contracts. So these are all actions pursuant to statutory authority, the context in which the president's constitutional claim to be is strongest. Okay. I talked about the Commerce Clause. Before I move on to issues of individual rights, I just want to say one other thing about the Commerce Clause in particular. It's a source of important federal, congressional power, but it also imposes some limits on state power, even in instances when Congress is not regulated. And so we have this doctrine, so the Dormant Commerce Clause, that says that states have some ability to regulate interstate commerce, a power that's assigned to the federal government. They don't have the same full power as Congress. Instead, a state regulation of interstate commerce is unconstitutional unless the state interest outweighs the burden on interstate commerce that results from the regulation. So whenever a state is doing something that is a regulation of interstate commerce, there's always a potential question whether it's exceeded its more limited powers to regulate in this area. State laws closing down businesses are subject to this constraint. I haven't seen this argument pressed too much in the litigation, and there's a fair amount of it around the country where businesses are challenging closure rules or other measures. There's one case out of Michigan in which the Department of Justice recently weighed in with a statement that the restrictions on business operations there violate the Dormant Commerce Clause. We'll see how that works out. And then just one more quick point on this. If you, a particular interest perhaps to those of you who are taking the bar exam this summer, we have I think it's 3 states now, New York, Massachusetts, and Tennessee, that have said, given needs of social distancing and so on, we can't accommodate as many test takers for the bar exam in the state as we traditionally would have. There are fewer seats, and the way that we're going to allocate those fewer seats is we're going to give an absolute priority to graduates of our in-state law schools. So if you are a graduate of the University of Illinois and you're moving to New York to practice there, the people in New York who control the bar exam have said, no, you don't get to take the exam because the seat is for the graduate from Fordham Law School or for NYU. You can take it later or maybe somewhere else in the state, an absolute preference for in-state graduates. This is obviously, plainly, I think without question, unconstitutional under the Dormant Commerce Clause. States may not, the one thing they may not do is just impose an outright discrimination, outright favoritism on the part of in-state entities. You can certainly allocate seats. You can't allocate it in that way. And I would flag, in this regard, our dean, Vic Amar, who's written about a great many things, but he has a recent piece at Justia on verdicts online. I think it's posted at our website, in which I think he offers what is just the best analysis of this. But we'll see whether the bar administrators come around. Okay, let's turn to issues of constitutional rights. And we've seen a bunch of cases around the country challenging stay-at-home requirements, business and other entity closure requirements. There's a fair amount of litigation on this front, and it's been in the news. And again, I'm going to focus on the federal constitution with a reminder that there are also state constitutions in play. and also statutory protections for rights as well. So it's not all just about the federal Constitution. And let's start with Illinois. In Illinois, we have a series of cases challenging the governor's extensions of the stay-at-home order brought by individuals, including by members of the state legislature, by businesses. We'll get to churches in just a moment, mostly in state court. Again, principally based on issues of state law and the state constitutional authority of the governor and issues of state statutory law, but with some federal claims sprinkled here and there. So, for example, Illinois State Representative John Cabello sued the governor in state court seeking very broad relief to enjoin enforcement of the stay-at-home order against any Illinois resident. It's principally a state law claim, a state law separation of powers claim that the governor doesn't have authority to act, and a claim about the meaning of the Illinois Emergency Management Agency Act and how long emergency orders may stay in place. But there is a claim that the order infringes a liberty interest in free movement under the state constitution and under the 14th Amendment, framed as a right to travel. And it's on that basis that the governor removed the case to federal court where it currently is. On this federal claim and others like it, this right to travel, there's both a claim of substantive violation restricting travel, and the argument is that yes, safeguarding lives is of course a compelling government interest, but a kind of blanket stay-at-home rule is not narrowly tailored because people around the state are in different circumstances, so a one-size-fits-all approach doesn't meet the strict scrutiny requirement. There's also a kind of procedural claim that the governor the governor himself just applied the order without an opportunity for an individual to be heard or to opt out. The order, of course, in Illinois is now lifted, modified. So I think portions of this particular case are largely moot. I didn't see a demand for monetary damages. Maybe there's been development over the last couple of days. But I will say, I think on the merits, this sort of federal claim is probably not strong. For one thing, the right to travel cases out of the Supreme Court typically have an interstate dimension to them. I don't know that you think about in-state restrictions in quite the same way. And on the strict scrutiny analysis, if you get to that temporary measures in the midst of uncertain risks, and with the ability under the order that's been imposed to leave home for food and medical appointments and other reasons, I think courts are going to be reluctant to invalidate on an individual rights-based claim bringing a wholesale attack of what the government has done. Governor Pritzker's inclination has been to remove cases from state to federal court, and I want to mention then, you might think about why, but I want to mention in particular a lawsuit brought by another state representative, Darren Bailey, against the governor. He brought a first round of litigation in state court purely on state law grounds. He obtained a temporary restraining order the cohort structured so that it applied only to him. So he was freed from the stay-at-home order. He then uncovered some internal materials and opinion by the Attorney General on the meaning of the State Emergency Management Agency Act that I mentioned a moment ago, that he said supported his claims that the governor was not permitted to order these sorts of things beyond 30 days, amended his complaint, still based on state law, still in state court. Pritzker removed the case to federal court, characterizing the state law claims as, well, really claims that the governor deprived the plaintiff of his federal constitutional rights, and that essentially the alleged violations of state law should be characterized as a violation of the 14th Amendment, 14th Amendment due process. Bailey said, no, this is all state law, belongs in state court. The U.S. Department of Justice jumped in, filed a statement saying the case doesn't belong, a kind of extraordinary statement. State doesn't belong in federal court. The governor shouldn't be manufacturing, seeking to spin these kinds of state law claims into federal claims to get into federal court, and supporting the emergency remand, which, as I said, I haven't checked in the last couple of days, but and so it may already have been, ordinarily have been been removed. But again, I think on the merits of this sort of general liberty, due process claims, or right to travel claims, courts are going to be very reluctant to invalidate wholesale stay-at-home or business closure orders with respect to temporary measures that involve a reevaluation to see whether they still make sense, and then extensions or modifications. Unlikely courts are going in a fast-moving scenario just to invalidate the whole thing. And I think this is particularly true at the appellate level. So one example here, Pennsylvania Supreme Court rejected a kind of wholesale challenge brought by business entities and some other entities, including a political campaign, based on state law issues, but also some federal issues under the First Amendment, right to assemble and so on. Pennsylvania Supreme Court rejected all of the claims. The litigants went to the U.S. Supreme Court. The U.S. Supreme Court simply declined to intervene. And I think that is particularly at the appellate level the general approach that we have seen and that we are going to see going forward. I think certain equality claims will get the attention of courts more easily. So most obviously, if I can't imagine that this will happen, but any sort of race-based or ethnicity-based classification that's adopted would be far more problematic for the government. Chinese Americans must undergo special quarantine, I think would easily be struck down. So equality differences, classifications may get more attention from the courts. This brings me then to religion, where there is a bit more variation. There are lawsuits around the country by congregations asserting that restrictions on gathering violate their rights of religious exercise under the First Amendment. A significant component, of course, of exercising your faith is coming together with others. And you might know here, my students will know, that there's a Supreme Court case called Employment Division versus Smith. It's a decision of 1995 by Justice Scalia that says that if you have a neutral law, that is one that doesn't target religion, generally applicable, it does not violate the First Amendment just because it incidentally burdens religious exercise, just because it makes religious exercise harder. In other words, the First Amendment does not require government to provide exemptions to generally applicable requirements that end up making services or other forms of religious exercise harder to pursue. So following Smith, then, if you think about this, a general ban as a result of the pandemic on more than, say, 10 people gathering together does not violate the First Amendment when it also means that no church service may take place. And on this logic, you have some federal courts, including in Illinois, rejecting First Amendment challenges to coronavirus measures. The problem, though, is that Smith says generally applicable. And as you know, the orders in place are not generally applicable. They allow some entities to operate, people to gather in some settings, but not others, including by designating some businesses as essential and others not. So then you have a line of cases, also from the Supreme Court, that says, now if a law discriminates against religion or regulates or prohibits conduct because it's undertaken for religious reasons, then the law is subject to strict scrutiny. A series of cases, the Hialeah case, if you're kind of keeping notes. The question then, in the cases that churches have brought, again, around the country, require deciding whether religious entities are being treated differently, and then what? The U.S. Supreme Court, again, this stuff sort of just keeps coming. U.S. Supreme Court last Friday had one of these cases on an emergency application for an injunction against Governor Newsom's order out of California, and the sort of reopening provisions there. The case is brought by the South Bay United Pentecostal Church. So under the California order, with the reopening measure, churches have not been allowed to fully reopen. They can at this stage reopen, but there are these numerical restrictions on gatherings, the lower of 25% of building capacity or maximum of 100 individuals. Same rule applies to concerts, theaters, sporting events. Doesn't apply to businesses, factories, banks, grocery stores, malls, bookstores, and others. And so in a 5-4 per curiam ruling that came down very late on Friday, the Supreme Court denied the church's request for an injunction. There was no opinion for the court, so we don't know, what exactly was the majority's ruling. Chief Justice Roberts wrote a individual, not joined by any other justice concurring opinion, explaining his thinking. And his basic point was that churches are not being treated differently in California in a legally relevant sense because they're being treated the same as other comparable entities that generated comparable risks, like a theater. The churches are not the same as, say, grocery stores where people are in and out. 4 justices dissented. Justice Kavanaugh wrote a dissent joined by Thomas and Gorsuch. Alito was also in dissent. He said these distinctions don't actually reflect risk health or risk considerations, and churches are being disfavored. He relied a great deal on an earlier decision out of the U.S. Court of Appeals for the Sixth Circuit involving churches in Kentucky, where that court said, it doesn't make sense for the government to assert these kinds of risk-based or health-based justifications for treating religion differently. And so we perceive kind of bias against religion, and the strict scrutiny standard needs to be met, and it hasn't. And it hasn't here. There's also been litigation in the Seventh Circuit. Churches in Chicago have sued in federal district court challenging Governor Pritzker's order. The district courts on roughly the sort of Roberts analysis that came before the opinion last Friday. Denied those requests for injunctions, said no, churches aren't the same as the businesses that have been allowed to open more freely. The churches went up to the U.S. Supreme Court again at the end of last week. Pritzker, however, lifted the 10-person limit that had been in place in churches that they were complaining about. And so the U.S. Supreme Court rejected the church application for relief, essentially mooted out, but saying if things change, you can come back. Very quickly, in just a couple of seconds, let me just flag some other individual rights questions that are in play or might be in play on the horizon. One is the operation of courts and questions about due process. I think particularly in the criminal context, when courts are closed. Here in Champaign, they're starting to open, but around the country, courts are closed, physically closed, operating online. Hard to see how you can ensure, say, the right to confront witnesses if you were to hold an online trial. I think this is potentially very problematic. Potential Eighth Amendment claims in prisons when prisoners are, as they seem to be, subjected to really extraordinary risks of a life-threatening virus. Let's see, other sorts of measures that as we start to open up, government might be contemplating. So things like tracking people's movements through cell phones, or maybe as in China and other parts of the country, a kind of health passport that allows some people to travel around, but not others. Cell phone data being used to track where you've been and who you've been in contact with. These raise First Amendment and other sorts of issues as well. The big thing, though, that's already generated litigation, and that is going to produce a lot of cases. We're not prepared for any of this. Lots of cases that are going to be around the country have to do with the election. This is not just an election year, it's a presidential election year. Voting is more dangerous. You have states that are trying to grapple with that, being sued because they're not making adjustments to their primary election processes, being sued when they do make adjustments. One case so far out of the Supreme Court involving Wisconsin and the court kind of on the eve of the election lifting a district court order there that would have allowed voters to send in mail-in ballots after election day, so long as they arrived up to, I think, 6 days after election day. The court invalidated that. This is the tip of the iceberg, or the first rumblings of the storm. We don't have in place sufficient mechanisms to to ensure safe voting. Election processes are highly decentralized. There's going to be litigation after litigation after litigation, some of it in the state courts, some of it in the federal courts, many people seeking to get to the US Supreme Court. Both before the election and I suspect and fear after the election occurs. That's the big thing to be watching. So with that I want to stop and let's see. I'm happy to go for a little bit longer because there are probably some questions. If not, we can just end. But if you have a question, I'd be delighted to hear from you. Again, if you have to sign off at this point, that's fine. But if you have a question, please please feel free to type it in the box. I'm happy to do my best to answer. Any questions? I mean, we are right at the hour, so I certainly understand that you are that the time is up. We have a couple of questions already. So let's just see what we might take a look at here. Right. So one question. This is from Matt Banach. What are your thoughts, if any, on the recent Illinois case, a case in which a retail running gear business sued to try to obtain temporary restraining order injunction against Illinois government tried to prevent enforcement executive orders requiring closure of business during earlier phases? If I remember right, this is all a state law claim, and so questions about sort of the scope of the governor's authority, and a lot of, and this is where a lot of this sort of stuff is being played out, particularly in states where you have divided government, say, or where you have a governor who's acting very aggressively on the sort of federal constitutionality of retail business closures. So I think I touched a bit on that. I think, as a federal constitutional matter, if you're talking about kind of limited closure provisions, if the state can put forth a health-based reason, then I don't think that the constitutional claim is very strong. There is this old case. It's called Jacobson versus Massachusetts, a 1905 case, highly deferential to the government, upholding on a very sort of deferential approach, a kind of mandatory vaccine program out of Massachusetts. There's questions about, well, how far does that extend? Would it extend to, say, a business closure law? I don't, and so the courts are kind of thinking about that. But I think the general response is that it's hard to see exactly what the winning argument would be by a retail business closure law. I mentioned the Dormant Commerce Clause idea. I think that's maybe the strongest. The kind of takings of property idea, I don't think that that's going anywhere. That's in play in a lot of cases. A sort of closure of a business that represents, not through any fault of its own, but because people are coming in, a public health threat, we close those all the time. And they're not, and courts routinely reject in other circumstances the idea that that's a takings problem. So I think, fairly weak claims there. Juan Mata asks, even when, as you mentioned, there's a right to travel among the states, wouldn't the pandemic provide for an argument on the police power to impose a fee? Good, so this is a good one. So we don't stop you from coming into the state, but we charge you, right? So there's a border set up. We're going to check your driver's license, and if you're from out of state, you have to pay because of increased healthcare costs. I mean, I guess that's one possibility. I think that's easily unconstitutional. States can't restrict entry. They also can't charge you to enter the state. Now, if you were to do something structured a little bit differently, so that you cannot, for example, as a temporary visitor in the state, have access to maybe say emergency health care and so on, unless you pay, that might be a bit different. There'd be sort of state law issues because we generally allow everybody to do that. There are Supreme Court cases involving those sorts of discriminations, but against individuals who have changed residency and moved into the state, states can't do that. Maybe the temporary visitor raises sort of some questions about whether issues of equal protection would allow the state to do that. Hard for me to see exactly how it would be structured. Certainly, the fee payable at the border, that's a non-starter. And this is a good one. Can Congress prohibit landlords with existing government-insured loans from evicting tenants? Very good. Existing government-insured loans. So I think that the big question here is what exactly is what would exactly be the constitutional objection? If you're talking about the federal government acting in a way that would interfere with, you say, government-insured loans. I assume you mean federally government-insured loans. Then we would ask whether it'd be a largely contract question. I think would ask what sorts of provisions are written into the contract. And the federal government is usually usually smart enough to include extensive provisions for modification of contracts under emergency circumstances. So I think it's sort of contract measure, probably pretty strong argument. As a kind of constitutional matter, then you'd start thinking about, say, the position of the landlord and losses that might be entailed. Could those constitute, say, a taking of property because the landlord is expecting to be paid rent, and now can the federal government say no money is coming to you, that the tenant gets to live for free? I think there is no contract clause that applies against the federal government. The contract clause, the provision of the Constitution that bars government from modifying contracts, such as a rental contract, is restricted to the states. But there may be analogous due process claims if what we're talking about is something more than a delay, and just the sort of law or regulation that has the effect that says someone gets to live in your property for free. I think that's probably a stronger argument. Can you compare pandemic regulations with citrus transport regulations in Arizona and California? I mean, these are, so I take it that the suggestion is there's of course fruit and vegetables, and the Supreme Court cases involving this that travel across state lines, and states sometimes want to protect their own industries, and so they start maybe to impose special requirements. The famous case involving a special requirement that you have to process and pack the fruit within the state if you're going to sell here, unconstitutional, or other sorts of restrictions that tend to favor kind of in-state interest. I think the lesson from that whole line of cases is that sort of discrimination by a state against out-of-state entities, particularly those engaged in commercial activity, highly disfavored. The states don't have the same broad power. Congress could do it. States don't have the same broad power under the Commerce Clause. It depends, of course, upon what the strength of the state interest is, and certainly protecting health is a strong state interest. But then we ask about the burden on interstate commerce that results, and if the burden is significant, and if the state goes about it in a very heavy-handed way, the state's likely to lose. If there are alternative ways in which the state might pursue whatever interest it has, then it might survive. But anytime you're drawing a distinction that looks like protectionism, even protectionism to say prevent health concerns, raises red flags under this doctrine. Let's see. On what basis can a state governor, this is a good one from Stanley Eisenstein, on what basis can a state or governor, impose mandatory quarantine restrictions targeting citizens of only a selected few states, right? So we actually have an example of this. So Rhode Island, for a period, the governor there had said, all these people coming in from New York. New York it's doing much better now, but New York is is, the epicenter of all of this. People are fleeing New York to come to Rhode Island to avoid what's happening in New York, and they're bringing in a virus. And so the proposal is a kind of short-lived proposal because it's unconstitutional. The short-lived proposal will set up a checkpoint at the border. If you're driving in and you have New York plates, we stop the vehicle and we tell you that you're coming into the state and you must quarantine for 14 days. Some vague suggestion that we might come around, find out where you're going to be, and we might come around and check up on you. Why is that unconstitutional? It's unconstitutional first because it probably violates the Fourth Amendment. I mean, driving in from another state with New York license plates is not a sort of reasonable suspicion of any criminal activity that would give rise to the vehicle stop and the questioning in the first place. But it's also unconstitutional because you can't, as a state, impose these kinds of requirements unless you can meet a really high strict scrutiny standard in a way that treats people from out of state differently from those who are in state, and particularly where there's an alternative, right? The alternative would be, again, setting aside the Fourth Amendment question, that anybody traveling from New York is going to be told to quarantine, and states do have broad powers to quarantine. It's not just the people who are the New York residents, as evidenced by their New York license plates, but anybody, right? That's your alternative. It reaches Rhode Islanders coming back from New York, and there are sort of political checks then on whether this sort of program is viable, but this kind of differential treatment, wholesale differential treatment, is almost certainly invalid. Maybe we'll take this as the last one. It's a good one to end from Stephen's iPhone. In your opinion, does the First Amendment right to protest in clusters outweigh the First Amendment right to pray in numbers? Oh, good. Let me give you the quick answer. So I wrote about this just now, not just now, last night, and I posted on this at Balkanization, in Jack Balkan's blog, which is a kind of prominent legal blog. And so here's the thing. So here's the context for it. So California, and it ties back to the U.S. Supreme Court's decision. Remember, I said California had said that the churches are not being treated differently. They're being treated the same as comparable entities where people are clustering together for extended periods and where the health risks are different in churches and concert halls and theater venues and so on, being treated differently from say, grocery stores. Because in the grocery store, you're not hanging out. In the grocery store, you run in, you grab your stuff, and you leave. And so the health risks are different. And so that's the basis for the classification. It's not religion. It's not anything about religion. Churches are treated the same as comparable entities. But what do we see? That's last Friday, right? And the court accepts that rationale, at least as far as we can tell, in the Roberts opinion. That's last Friday. What have we seen since then? Mass protests in California and around the country, hundreds of people, thousands of people marching all throughout California in response to, of course, police violence, a serious problem, but either marching or standing in public squares. 2 days ago, thousands of people assembled outside the Los Angeles mayor's residence, jam-packed, shoulder to shoulder. California is not dispersing those crowds on coronavirus grounds. I'm not a health expert, but if you just take seriously what California had represented to the U.S. Supreme Court about the basis for the kinds of activities it's allowing and those that it's not, these look like they fall right on the side of the unhealthy activities. Large numbers of people crammed together, shoulder to shoulder. You look at the images, some have masks, there's very little social distancing. Some don't have masks, some have masks kind of dangling under their chins or that they're holding their hand. People are lying down in close proximity. And it's all sanctioned, except where it leads to violence, by California. Governor Newsom gave a press conference on Monday in which he praised these activities. He was asked, this is in a church, by the way, and Newsom is not wearing a mask, by the way. He's asked, Governor, aren't you concerned about the potential spike in coronavirus as a result of these huge numbers of people coming together? And he said, well, I hope that they will get tested. So this, to me, raises now a new potential claim by the church that had lost at the Supreme Court on Friday. If the state of California is willing to allow, as it does, those kinds of mass protests, people jammed together without masks, shouting, singing, close proximity, touching each other, some state officials involved in close proximity, some not wearing masks, then we start to wonder about the state's representation, right? That the church can't have more than 100 individuals together, even when the members of the church wear masks and follow social distancing. And so, I don't have a dog in this hunt, but if I were the church, I would be back to the Supreme Court. The recent actions in the current legal posture of the state of California really does cast doubt on whether this is, in fact, the distinction. There's health-based, risk-based. This is the distinction that California is drawing. And the answer can't be that the protests represent a right under the First Amendment. Why is that? Because there's a right of religious exercise under the First Amendment as well. So that's even across the two settings. So this is good, and lots of moving stuff. We could do another event tomorrow. I'm not going to, but another event tomorrow, and there'd be a whole series of additional questions. I would love to hear. You can email me about perhaps any experiences in your local communities, especially from lawyers and the operations of courts. As I said, this is a big thing. How we ensure due process and the rights of litigants, especially in the criminal context, when things have moved onto Zoom, and when there's really just sort of variable ability for even the public to listen in and monitor those kinds of proceedings. So as a lawyer, if you have any experience with that, I would really, I'd love to hear from you. This won't be the last word on any of this. I look forward to doing another program, perhaps sometimes down the road. As I said, we have a series of additional CLE programs coming up, and I encourage you to join those as well. I thank you so much for listening in. Thank you all for those questions. I think they're wonderful. I appreciate it. Take care.